Margaret. Appreciate your contribution. Particularly from my point of view, you've given me a new synonym for Edmonton on the North Saskatchewan. We call it Moscow on the Molongala. And indeed, our climate is probably closer to Moscow's than anything in Canberra. Now, we have about 10 minutes to go for questions. So I invite you to stick your hand up or walk up to the mic and have at us.
I'm Brent Cotter from the University of Saskatchewan. I didn't plan to go first, but I did when I heard it was only 10 minutes left, John. Let me begin by saying that...
Try not to use all of them.
I was inspired by what Kim had to say and look forward to reading her paper, and I agree with nearly all of what Ian had to say, but my comments and questions relate to John's observations, if I may, John, and just a bit of two questions. One relates to the Ethics and Professionalism course, mandated for an approved degree by the Federation of Law Societies, and the other relates to the overall project and its motivation. Some of this you and I have discussed in private before, but it seems to me, especially in a location like the University of Alberta, which was probably the first Canadian law school to introduce compulsory ethics, something that I personally support, and if it's done right, I'm guessing even Harry would support in the legal education environment. Two observations. You indicated that it was the only course that is specifically mandated as a course. I would suggest a little disingenuous when you say competence in contracts. We kind of guess how we will do that in law schools. But the only course mandated. But what you didn't say is it's also the only course in which content is mandated. And I'd like you to maybe offer an observation or two about that. That seems more intrusive by far than other dimensions of what the Federation did. Secondly, in that context, at the time that that was implemented, a year or two earlier, the Law Society of Upper Canada withdrew from teaching legal ethics in their bar course at some significant financial saving to the Law Society of Upper Canada. I guess I'm inviting you to respond to Harry's question about where was and where is the profession in terms of financial support for a mandated expectation. My second question relates to the overall project. I suggest to you as a proposition, which I think is a compelling one, that Canadian legal education is stronger by far now than it was in 1957 or 1968. The students and graduates are better, the teachers are better, they teach in a more modern way, which one would normally think as a suggestion that the graduates are actually better than the folks out there in the profession themselves, and I would include myself in that crowd of people. You indicated that there were these three external forces, the NCA issue, challenges with respect to mobility, and the fair access legislation. Three problems that exist in other sectors, and one interpretation is that to solve that problem, you visited an unnecessary regulatory structure on Canadian law schools. Associated with that, at the same time, across the Commonwealth, are pressures on self-regulation, and one suggestion, a somewhat cynical one, might well be this would show in the Canadian context aggressive moves to self-regulation, but by the selection of low-hanging fruit. We'll regulate admission to the profession, but it'll be for others, law schools, to do the work. And especially when the objective is competency, and Harry points out that that's the thing that law societies regulate the least. There are 140,000 lawyers out there. Competency is a question. Nothing gets done on that, but competency to enter becomes the focus of the Federation's work.
Thanks. You now have 2 minutes to answer that.
Let me just deal with the second question first. And I'll just deal with it briefly. I think that there are a couple of things going on from outside the law school, impacts on the profession. You're quite right. Self-regulation is under attack. I don't think there was any, I didn't set up the task force. I was just asked to serve on it, but I don't think there was any sense that we'd better be seen to be doing something. But at the same time, I think there has been an increased awareness at the Law Society level that we have the privilege of self-regulation, and we ought to make sure we're doing it properly. This is by no means the only area in which we're moving. The Federation has tried to adopt national standards in a number of different areas, and they're all challenging. I spoke about the admission standards for entry to the practice, but the other challenge that we've had recently is trying to develop a national professional code of conduct that can then be hopefully adopted by the law societies. And just as you all resent the profession intruding on how you want to run your law schools, the law societies also are used to running themselves in their own way, and the Federation certainly has no authority to tell them to do anything different. But what we're trying to achieve are national standards across the board in every respect. I guess this was the first one off the mark, in part because the Law Society of Upper Canada established a committee to look at this issue of common law degree, and many of us outside Ontario felt that if this was going to be examined by the regulators, it should be examined by a national task force, not by an Ontario task force, because we wanted sort of a national standard. So it wasn't, so far as I was concerned, an effort to go at low-hanging fruit, but it was part of a national standards momentum that has been building for some time and will, I think, continue to build. For example, we talk about discipline. There is a group looking at national standards for discipline of lawyers across the country, and that's never been done before. In every province, every law society has developed their own methods of handling this, their own criteria, their performance criteria as to what's satisfactory and what isn't satisfactory. So that's quite a project too. I think right across the board we're going to see a lot of what law societies do in a regulatory way influenced by a national approach. So that is what I can say on the second. I guess the other question was the sort of downloading of cost onto the law school for professional ethics. And I guess what I can say is that it wasn't intended in that fashion. It was intended to set a standard for entry to the bar program, and there seemed to be a significant rationale, both coming from the Carnegie Foundation and from other comparative jurisdictions which require professional ethics to be taught, and a significant momentum in Canadian law schools already to include ethics and professionalism as part of a core course. About half the law schools required it when we were doing our work, half didn't. And the question was, do we regard this as being important for entry to the bar program? We thought it was important. It also gave us the ability, because it's Canadian legal ethics and professionalism, to say to foreign trained lawyers that you're going to have something more. You're going to have a Canadian legal ethics and professionalism course or focus, because that's what we're requiring of all of the entrants, including Canadian students. So that was the question of what the profession can do. I have to say I've been disappointed in the Law Society of Upper Canada's several of their the steps that they've taken with respect to their bar admission program. Outside of Ontario, I think you'd find that the law societies aren't withdrawing from these areas, that they are putting money into it. We have a 10-week skills training program in British Columbia that I think is very highly regarded as a transition into practice. Ontario has their own challenges, and I'm not really competent to talk about those, but certainly outside Ontario, I think that the law societies are meeting the challenges that they have to provide that transitional training.
Matt, you had a question?
I'm just following up perhaps on Brent's earlier question, and it was a question to be followed by a comment. Is to what extent do members of the legal profession consider themselves part of the law school, and to what extent maybe should they regard themselves as part of the law school? And with respect to legal professionalism in particular, I teach professional responsibility from time to time. Just to give you an example of a couple of topics, when I talk about civility, I talk about it knowing, against the background, I've never personally been witnessed a student acting in an uncivilized manner towards me in the classroom, and I'm sure many of my colleagues feel the same way. But based on my experience in courtroom and in exams for discovery, or in talking to my friends who are still members of the profession, I know from experience they're very likely to have their first experience with uncivilized behavior in the legal profession in that context. The second one, it would be unethical billing. It is a topic that I cover in my course, but to find materials on it, one has to rely almost exclusively on Professor Woolley's article, because it's the only article out there that's actually brought this up. And I do so with ending my topic by saying, you know what, even if you start, they start asking you about pushing the envelope. Students are interested learners. They want to know what the boundaries are. But I have to end with talking about the most you're probably going to get is taxed. You might go before a taxation officer if the client is cagey enough to figure out that they're being billed in an unethical fashion. And so even in teaching it, the frustration that I feel is that on the other end, side of the wall, and I suspect there are two silos here, not just the law school, but the legal profession as well, that the educative aspect runs out once they leave the law school. And this, I'm not targeting poor Mr. Hunter here. I am actually looking for other members of the panel to comment on this as well. Thanks.
Well, I'm happy to take a crack at it. I mean, the Law Society that I know best is British Columbia. We have an ethics committee that looks at issues as they arise. We have a code of conduct. The Federation has, as I mentioned before, developed a national code of conduct. The actual enforcement of that code depends largely on what the law societies are told. That is to say, someone generally has to make a complaint. Billing is a tricky area because sometimes the clients won't know and then won't complain, and the law society won't find out about it. I think there, in my last decade, when I've been doing a lot of law society work, I've felt a considerable uptick in attention on doing a good job as well as we can on the regulation side. Billing is a tricky one, and I don't know that we do the best job we can do on that one. I agree with the general thrust of your question. I think the law societies ought to be a little more engaged in that. The answer I usually get is they can take it before a registrar and tax the account, and the registrar will cut it down if there's something wrong with it. That's the answer that I get from my fellow benchers. I'd like to see the law societies a little more aggressive on that, but I have to agree with you, it hasn't really happened.
I'm not sure I can answer your specific question as to whether or not lawyers should view themselves as part of the law school, but I would say that we should view I'm a romantic sort of person by nature, and I can indulge in idealized sort of views of things. So in my sort of romanticized way, I think that we should all think that we belong to the same community. You know, the best lawyers I know are lawyers who can reason from first principles and then use the fruits of that reasoning to do things to help people. So I don't find it alien at all to sort of engage in a discussion, a jurisprudentially based or more frequently legal history-based discussion with lawyers who are existing in the practicing world. And so to me, it's a false dichotomy. You know, in the English taxonomy, we traditionally, which we received, we talk about barristers and solicitors. I actually think that there are three segments to a common profession: barristers, solicitors, and academics. And so I think we're all in the same game.
Please.
Hey, not to pick on you.
I'm just going to move a bit over here to the left, John.
You've already
It's not
kind
completely unexpected.
you've already kind of addressed a lot of the things, but like as a student representative, I do really worry about the law school's capacity to kind of like diversify how they try and do things, because like just as law schools don't operate in a silo, and Professor Lewins, yeah, nailed it. Just as he mentioned, the legal profession doesn't operate in a silo either, because that's the problem is, again, we've mentioned that law schools have one step in post-secondary education and one step in the professional education field. So when you have governments kind of holding budget dollars hostage basically telling your schools, like, you have to be a lot more experiential based, you have to practice a lot more substantive law based, and then you have the federation on top of that saying you have to have these courses and these courses. And then as well, like the number one concern that always comes from students is jobs, 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 and then a few more jobs on top. So like to say to law schools, like, well, that's up to you to like have that conversation with students about like what they want out of their legal education. Just with like the tuition the way it is, they're bound to say like whatever we got to do to get jobs at the end of the day. So like with the student pressures and then the federation pressures and then pressures from individual governments, I do worry about law schools increasingly being put into a smaller box and then being asked to like play within that. And with the rapidly changing legal profession, I'm a little torn on like whether or not that's the best direction. And then I do have a question for the panel, just in like 50 words or less.
It's a haiku. You want us to do a haiku?
25 words for you then. Basically, so this Sunday we're having a teleconference with 13 out of the 16 student representatives with 13 out of the 16 common law institutions about talking about these issues on a student level. If you could say in 50 words to students what they should be asking from either their law faculty or the legal profession, what would that be?
That one, please. Oh, it's more interesting. I know that's more interesting.
Well, yeah, I mean, what I was trying to articulate was what I saw as the value of both an academic and a professional education in law school. I don't see them as being separate. I mean, they have different components, but it should be integrated in my view. If we take a purely academic course, as far as I'm concerned, that's part of your preparation for being a lawyer. It's not something separate from that preparation. So I think that's all that really the profession would say in most cases. Is we'd like to see just both on the table. That's all. And if the law school is directing itself to both, I think the profession would be happy with that. And law students should apply themselves to the academic programs every bit as much as anything else, because that's going to be very important in the practice. No two ways about that. And that helps.
Just for amusement, I think you should ask your faculties to be engaged in the big intellectual problems that real people have, and just be fully intellectually engaged. I can't remember who made the distinction before about confusing volume with, intellectual engagement, but it was beautifully done, right? So you should just say, like, you need to be fully intellectually committed to this project of solving human problems, and if your school's not doing that, then you should demand something different.
Any other questions?
I really enjoy this panel, and since I have this great difference of perspective here, let me ask this question. The distinction between practice and theory that we've been talking about here seems to me to be almost unique in law schools. If you go to top graduate schools of business, they are passionately interested in what business people do every day and how business schools can help make it better. If you go to engineering schools or veterinary schools or medical schools, the faculty's research is focused in large part on how to make people do what they're doing better. And in the law field, we seem to think that focusing on how an individual, research on how the system could provide better, cheaper legal services to ordinary people is one that we don't even study. I mean, the fact, I'm blanking on the name, I've met a lot of new people here, but the gentleman who said how there's no research on what new lawyers need to do strikes me as an enormous indictment of us, in that shouldn't we be studying what new lawyers need to do? And I'm just interested in your reactions to that.
Yes.
I wanted to give you a softball.
Thank you.
Any other contributions?
I think, well, anyway, you've inferred this already. I think it's a false dichotomy to talk about the difference between skills and theory. To me, that they're done well. To do either of them well, you have to intertwine them with the other. So I really think it's a false dichotomy.
I think it's also partly historical. because in the great universities of the Middle Ages, it was only jurisprudence, Roman law, and legal history that were taught. And law for practice was taught in the Inns of Court, so there was a very clear distinction. And then there were great debates in the 19th century as to whether law should actually be taught for practice within universities, because it was seen to be inappropriate. And I know at the University of Sydney the debate went on for 40 years. There was such antipathy towards that idea. So I'm sure that sort of history is part of it, and I've certainly been intrigued by the fact that medicine and engineering are not beset with angst in the same way that legal academics are about, whether they belong in the university or whether they really belong with the practicing profession.
One final quick question, that'll bring it to an end. I'm under a clock, just as I put other people under a clock, and Eric is wearing it and showing it to me. So, one last question.
So Doug Harris from the Faculty of Law at UBC. Kim, loved your exhortation that we think big, particularly when we're mired in the detail of minutia. So I'm giving you a blank page and asking you to pick your one big, if you could introduce the big idea in admissions or any part of the curriculum, what would that be?
Well, that's my life problem, Doug, is that I'm not that attached to what it is. You know what I mean? I like trying to think about what will make us think about the world and law in new and different ways. And I don't care that much about the direction that takes, which is why in some ways I think Ian and I take issue with each other in the sense that I wouldn't prescribe that people teach those courses or not, although I love all those courses and I think they should teach them at Calgary. It sounds amazing to expand your program in all those different ways, but I don't, because people in the law school then think differently and students will be prepared in different ways and they'll engage with each other when they graduate and they work together in a profession in different ways, and so I like all of those ideas. So that's the kind of real problem for me, is not in generating all of the kinds of interesting things we could do if we articulated our commitments and then tried to meet them, but in our failure to articulate those commitments and actually try to meet them.
Well, that will bring our session to a close. I think that's a very timely comment for ending a session of legal academics and lawyers. We ended on a positive, passionate note of ambivalence. That's the kind of thing we all do best. And so with this, please enjoy the wine and cheese reception. And again, remember, it's brought to you by Tories. Thank you.